we all know one of the impacts of this recusal, of this decision by Koen, is that the entire case will have to essentially start again, only now in April. Mbekezeli Benjamin joins us from the organisation Judges Matter. Mbekezeli, good afternoon to you. We've seen quite a few of these applications for a judge to recuse themselves. Under what circumstances should a judge take that decision to remove themselves from a case?
Good afternoon, Stephen, and to the viewers. Well, the test for recusal was set out by the Constitutional Court in 1999 already, in a case that was involving then President Mandela against SARFU. And what the court said is that for a judge to recuse themselves, there must be a reasonable apprehension of bias on the part of one of the parties in the case. And sometimes this is difficult to ascertain, because essentially what the court looks at is the state of mind of the person who wants the judge to recuse themselves. So the person must, with the reasonably and with the correct information, when looking at it, they must feel as though the judge will not be able to be impartial. They might not be able to approach the case with an open mind. So that is the test for bias. And the circumstances, they vary. In criminal matters, for example, usually this relates to the fair trial rights of the accused. So the accused must feel confident that the judge will be able to rule impartially in the case. And if they cannot do that, then the judge will be violating the right to a fair trial in terms of Section 35 of the Constitution.
Doesn't it set up a little bit of a philosophical trap? I mean, someone can keep asking a judge to recuse themselves, ask again and again and again, and just because they don't, then claim later that there's bias, if you see what I mean.
Well, not necessarily. The judge has to give concrete reasons why they accept that explanation is reasonable. So, for example, you would have known in the past that when Justice Zondo, for example, was asked to recuse himself from the State Capture Commission, he said, look, the reasons that have been given do not give rise to a reasonable apprehension of bias in that particular circumstance. And today, Judge Koen exercises that same kind of mindset, but looking at the reasons given. And he believes that based on the statements that he had given in the past, that there is sort of grounds for him to recuse himself. So it's not an easy exercise. It's not mechanical at all. One has to look at the facts and circumstances of a particular case.
Former President Jacob Zuma keeps attacking the judiciary in different ways. There's been quite a lot of public criticism from himself and his allies towards the judiciary. I mean, could that be used to argue that because of that, no judge could hear this case?
Well, not necessarily. You can't have a blanket view like that to say no judge can hear the case, because each judge will come to the case with his or her own mind, and they might view the same circumstances differently from another, and which is why the facts and circumstances, the reasons why a recusal is asked for and the reason a recusal is granted has to be looked at within the constraints of the facts that are before that particular judge. So even though Judge Koen makes reference to previous statements that he's made in a previous judgment, it's still in relation to this specific case. Judge Clearly, who's now come onto this case, might maybe a recusal application might be brought against him, and he would have to look at the facts and circumstances that are at present at that particular time. So it is not a blanket view. It's not a sort of a get out of a jail free card. You have to use it within a particular set of circumstances.
And what this does do, of course, is lead to another delay, and we've seen many delays in this case and in other cases. I mean, it seems sometimes our entire judicial system could be defined by the word delay.
Well, yes, that's our biggest concern around this, is that recusal does sometimes cause a delay in the proceedings. It does, if you look at civil cases, for example, it does increase the costs of that particular case. But the sort of the benefits, or if you were to weigh up the two options, is that now at least the case can proceed before an independent judge in a way that both parties will feel comfortable to be before them. So that's why, again, I say it's not an easy exercise. Recusal needs to be grounded on very strong reasons. It cannot be just given for the taking.
Mbekezeli Benjamin from Judges Matter, really appreciate the time. Thank you very much indeed. We'll stay